February 3rd, 2026. This is that day, and this is the day that Charlie Adelson's attorneys will argue for a new trial in front of a panel of 3 appellate judges in the First District Court of Appeal in Florida. But will it work?
Welcome to the global phenomenon, Surviving the Survivor. Here's your host, Emmy Award-winning journalist, Joel Waldman.
What's up, SDS Nation? Welcome to the global phenomenon that is Surviving the Survivor, bringing you the very best guests in all of true crime. We are like New York City. We're the podcast equivalent of New York City. We never sleep, and we are back. 3 shows yesterday. We are following very closely the developments with Nancy Guthrie, Savannah Guthrie, the NBC Today Show host's mother, and we'll bring you that today. We're going to bring you a show, but if there's any breaking news on that front, yesterday Brendan Banfield was convicted and will almost certainly spend the rest of his life in prison without the possibility of parole. And another guy who's doing that right now is Charlie Adelson. But today, his attorney, Michael Ufferman in Tallahassee, is going to argue for his release. And here to help us break this down, Prof. Joe Explains, Professor Joe Patuto, Professor Emerita, University of Nebraska Law. She is here. She, like myself, not big fans of the early morning. I guess it's not early morning anymore, but it feels like it. And Jared Ross, you guys know him. Familiar face, a friendly face, a sweet face. In Hebrew, it's the word punim for a face. Look at that punim. Jared Ross, good morning. How are you?
Doing
Joe
well,
Patuto,
thank you.
Yeah, Joe Patuto. Good to see you as well. We're going to, I think Space Coast has the shot up. COE, I'll let you and Spacey figure that out. But whenever you want to bring the shot up, we are looking at what Tim Jansen has described as the Taj Mahal. Now, Tim Jansen, to the best of my knowledge, is actually going to be at the hearing, and he has a link to join. And I think he's gonna. And there it is. Jared, I assume you've been here at one point in your life, Tallahassee life. Describe the Taj Mahal to us. It looks pretty fancy to me.
It's in the neighborhood I live in. So it's right around the corner from my house. And my old office was actually right next door. So I'm very familiar with the Taj Mahal, very familiar with that building. I've never been in there to argue a case, but my wife has. It is very famous here in Tallahassee because of the circumstances around building the facility. The First District Court of Appeals used to be downtown Tallahassee. It's a building that is now owned by Florida State University College of Law, and they do trial practice and things like that in that building now. The legislature appropriated money years ago to build a new District Court of Appeals in Tallahassee, and there were some circumstances that may have been considered shady at the time, and it caused a lot of controversy. There were some judges that were investigated because of it. I can't remember for sure if any of them received any reprimands or anything like that, but I do know that the judge that was the chief judge at the time ended up eventually retiring. Now one of his sons is actually a judge here in town, but a lot of interesting history.
I was going to say her name's not Jackie Fulford, is it?
No.
Okay.
But it was it's a beautiful courthouse. There was a lot of hope that the appellate division of the Attorney General's office would actually move in there to make it easier for them to attend oral arguments. That has not happened. They're still here downtown, so they have to travel the long trek of about 12 minutes to Southwood in order to be able to go ahead and do their arguments. But it is a beautiful courthouse.
Yeah, someone asked if Tim is in a blue suit. It's hard for me to see. He might be in the gallery. Tim did say he was going to go. So we'll get that shot back up in a second. But Joe Patuto, Tim is in front of Abby. Okay, we've got Abby Crossing, a member of STS Nation, in there along with Tim Jansen. There you go. Joe Patuto, all you have to do is look at that. I mean, it's not the Supreme Court of the United States of America, but it's also not courtroom 3G. It's as Tim describes it, the Taj Mahal. It's impressive. Michael Ufferman has argued, and he's a very skilled attorney. Does the moment bring any jitters, do you think, to him, especially defending a high-profile client like Charlie Adelson? You think Michael Ufferman right now is, I don't know, just using the bathroom to freshen up because he knows it's a big moment?
I don't think he's doing that, but I wouldn't be surprised if he has a couple of nerves. It's pretty hard, no matter how many times you've done it, to avoid feeling, a little bit nervous before you start. You get past it as soon as you start making the argument, but I'd be surprised if he doesn't have some jitters.
Yeah. Jared, I assume this is actually normal, but someone's asking, why are there only 7 people in there? I mean, this is very big in our world. It's big in the Markel's world. It's big in the Adelson world. But I mean, people in Tallahassee, there a lot of people are very interested in this case, but that doesn't mean people are necessarily going to travel out to the courthouse to watch it.
Yeah, this is so different than a trial. You have to remember, in a trial, you have days of testimony, you have direct examination, cross examination, opening arguments, closing arguments. There's just so much to it. This is a 40-minute oral argument. It's not as exciting as a trial. In fact, you may not even get to hear all that much of their arguments. The minute you get up there and you say, "May it please the court," and you start your opening, you could get interrupted right away, and the judges just start firing questions at you. This is not what we're used to in the back and forth between a prosecutor and a witness, or a defense attorney and a witness. It's very different. And again, it's 40 minutes. So where we had people traveling across country to sit in days of a trial right outside my window at the courthouse, you're not going to have that, because this is, again, only 40 minutes. This is not something that's going to linger on. So for those of us even here in Tallahassee that are extremely interested, I can tell you, I wasn't just going to drive up or even drive around the corner before I came downtown to the courthouse and sit in there, because it's not the same thing as going to a trial.
Tayo Toy says he's watching from his Ferrari F40. Must be nice, Tayo. I think that might be a joke, but I hope it's not. How can Queen Georgia, Joe Patuto, not be there? Wouldn't she be so interested in watching this from the gallery? She is the GOAT. You think she's watching on STS right now? And Zimbabwe's in the house.
I guess I'd be a little surprised if she's even watching it from her office, but I don't know of a case in all the appeals I've seen where the trial lawyer showed up to watch. I mean, they could, but, I think they generally feel they did the trial, now it's out of their hands, and the expert appellate lawyers will handle the next step. I actually don't think it would be a bad idea, however, because I don't think we do a good job at any stage of alerting the people who had the hands-on responsibility if something goes wrong, what it was that happened. We don't do it very well with the police on a search and seizure where there's a suppression motion. So I think it would be a good idea to do more of it. But, everybody's busy doing other things, so it's tough to squeeze.
Yeah, and I will say, well, first of all, Georgia could be in trial this morning, too, for all we know.
Right.
But I will say, and without getting too deep into what I do know, because, again, my wife works in the office with Charlie Lee, who is sitting there and is going to argue the case for the state. They are in direct contact with the state attorney's office at all times on all of these cases, not just this one. My wife, for instance, she talks to the state attorneys on her cases throughout the time where she's preparing the brief. If she has questions or concerns about something that's in the trial record, or she needs clarification, she's on the phone with the state attorney. So it's not like they don't work together on these appeals. But again, there's no reason for Georgia to be there. She has access to, if she wanted to watch it either live or recorded, she can do that. But again, very well could be in a trial right now for all we know. So she's got a job, which is to prosecute. The prosecution has taken place. They got the conviction. Now it's up to the Criminal Appeals Division of the Attorney General's office to handle this case. And they do a tremendous job. I may be biased, but they do a tremendous job in that office.
Yeah. It looks like Michael Offerman is walking around with his hands in his pocket.
Yeah,
he's pacing. Yeah, he's pacing. But Jared, Charlie Lee, you mentioned him. That's the gentleman sitting on the desk to our left. If you're looking at the screen, tell us a little bit, about him. Who is he? What does he do?
So he is a assistant attorney general in criminal appeals. He has been there quite a long time. He has been the appellate attorney on all of these cases for the Markel trials. He knows this case backward and forwards. They have done moot courts where folks in that office sit in and they act as judges and they ask questions that he would expect to hear based on his brief. This is a guy that, again, like I said, he knows this case backward and forward. He knows whether or not they have a good case, whether or not the Charlie's team has a good case or not. They don't, and he is prepared to do this, as you can imagine. This is the first oral argument that any of these appellate cases have had for the murder of Danny Markel, but he's ready to go.
Yeah. Joe Patuto, we are literally a minute before 10 o'clock, and this is supposed to start right on time. And I know Spacey's on this. Mm-hmm. Not sure if we have audio being funneled in yet, but is it still the voir dire issue front and center here?
I don't think it's I think it's the sitting of the jury venere and not going back out and starting again. I think that's the only one that has any merit to it.
Okay, so do you expect?
Jared, I was going to ask, Jared, do you know about these judges? Is it a hot panel or do they simply just listen? Do you know anything about them?
I know two of the three judges. Lori Rowe, she is very well known in the legal community in Tallahassee. She graduated from FSU College of Law. She's taught at the College of Law. She has done private practice. She's very smart, and I would be shocked if she just sits back and lets arguments come. I also know Judge Winokur. He actually worked in the Criminal Appeals Division of the Attorney General's office for a while before he went to the governor's office and then became a county or circuit judge, and then now he's on the DCA. Again, really good at what he does. He knows this office very well, the Attorney General's office. So again, I would be surprised if he doesn't pepper them with questions, both sides. I do not know the third judge. I think it's Judge Thomas. I don't know her, but I have heard she's really, really good and, again, very thorough.
All right, here we go. Let's listen in, everyone.
Whatever he said, I didn't hear.
Yeah, he said no cell phone usage, no photos. We're getting ready to go. So hopefully the audio is going to be a lot better than that. Let me tell you, I don't know that he was speaking into a mic, but
again, he stood in front of the well and did not use a microphone. So hopefully the microphones are connected to the audio.
I hope so too, because I didn't hear him at all.
Well, there was a caveat on their website saying, barring technical difficulties, we will stream live. So this is not a great.
All right.
There we go.
First Court of Appeal is now in session. All who have this before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
I love it when they do that. I wish he'd done it more slowly.
God save the United States.
I just think that's a great way to start.
Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning. May it please the court, Michael Luffman on behalf of the appellant, Charlie Adelson. Seated with me at counsel table is co-counsel Laurel Cornell Niles. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
I'm hoping to focus the beginning of my time this morning on the first 2 claims, which are the jury selection claims, and I think they're intertwined. And then I also intend to briefly address ground 3. So let me begin with the jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors, jurors 51 through 102, for reasons that I'll get into in a second. Let me begin with the change of venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know, and my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw, and I think that's right, but wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994 or what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, court TV shows.
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client was innocent. So we don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial, when you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly, no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, 3 actually. Just quickly regarding my client accepting it, I don't know that my client accepting it matters much. I think the concern is, did defense counsel renew the objection? The state made an issue out of that, and if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
No,
was there an
I
objection?
understand. But again, to that, I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it, but my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental error
Well, my understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is, in fact, a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with a change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental or claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion, and they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved, and they did so under the fundamental error standard. And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure, well, yes, but so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said, for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying, at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question, rather than to Mr. Adelson, do you accept this jury, and let me point out you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
It
fact.
sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal, and that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But
are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is, it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike, because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting in my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll do the same thing for the state.
Thank you. I appreciate that. I do need to address, so we have, and I've already talked about this, the almost 40, or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that.
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse. Again, we can't presume that, can we?
Let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court, asked point blank.
So are we supposed to just assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented him to the trial court where that juror had said that the parents of Professor Markel should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those 2, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that, and going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number 1, that jurors have not followed the judge's direction, so much so that the judge, when he heard about this after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this: high-profile case, it's the Charlie Adelson case, it's the Dan Markel case. Which of the... And that he's guilty... But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right? So we have one where a juror said, we'd been talking about it all day, is literally the quote. We have another where there's some pretty...
Talking about it, I mean content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the two jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C, on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the entire, that set of the panel. So let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again, and the judge said from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names, I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty. But don't we typically, we're going to strike a panel, or require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually said.
But the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
Oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty, and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the third group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of this speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that has disclosed that they've been talking about the case, and it's getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors, and 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done. And because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes, and the same for the state, so you'll have a total of 8 extra minutes.
Thank you.
Certainly a vigorous defense. That was Michael Offerman,
May it
the
please the
appellate
court.
attorney for
My name is Charlie Lee. I work for the Attorney General's office, and I represent the state of Florida in this case. I'd like to start out with the questions that judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The three justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now, from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice. To his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew new specific challenges to specific jurors. It is a much broader, as Mr. Efferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where, Mad Dog Irvin was in the press, as a serial killer, in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I'd point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe, several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree with Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know, there's no indication that this young man stood up on a chair and yelled this out at the jury pool in general or whispered it to someone. We don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue or denial of a change of venue motion or prejudice within the community or bias amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there, and McCaskill, there the courts, and it came long after Manning, they've developed a test to find out. And this is why, in this case, we had 2 voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge or a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And And all of these jurors, Mr. Adelson agreed to.
Could you address, the preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, a fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to an impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing in the record.
I think his argument is that the media saturation implicitly biased the jurors, I think is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did in fact lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error, and Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media, publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice, there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief, again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. Adelson, the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that I understand Mr. Adelson's arguments at times have changed, but I don't think people have. When we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
As long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markel's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with his Lords of Chaos group. I agree with you, Your Honor, that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate that there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or sort of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking
affidavits.
about the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at, just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing. In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if you file it before, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is, a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant. But the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Ufferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him. Is it
really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes, sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markel.
Michael Ufferman with
May it please the
rebuttal.
court. I'll begin by briefly addressing Claim 3. here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and say...
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be... I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way even in a slight way relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting, and he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it.
Right.
That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury. So is that the correct standard to be used in striking an entire panel?
I think that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case.
Counsel, my colleague has a question,
of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case, and that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error, and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor, and it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case, even though the court specifically said don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.
Jared, the middle judge is the one who teaches at the law school?
Has taught at the law school. I don't know if she's currently doing it.
Didn't that sound like a law school class?
Oh, very much so.
All right.
Flashbacks.
So, you just heard it. The appeal in Charlie Adelson's case, the appellate hearing just now. Court started. It was supposed to be 20 minutes aside. Time was extended on both sides. It is now 10:58 Eastern time, and this started pretty much on time. So in total, with the shuffling back and forth and extended time, we went about 58 minutes. Joe Patudo, really the crux, or one of the cruxes of Michael Offerman's, and I'm going to have you unpack this, and I think we're going to hear from Tim and maybe Abby Crossing, who are both inside the gallery. They will come out. But really, it had to do with the media coverage and others inherently biasing the jurors, and Michael Offerman talking about these 53 of 54 jurors who had a strong opinion against Charlie Adelson, the judge pointing out that those jurors were struck, and then we went back and forth. I took pretty copious notes. We'll go through it, but what was your overall take on this? It was fascinating to watch. I'm sure it is a requirement of law school students to watch an appellate hearing like this. I can tell you firsthand, Jared, with all due respect to your wife, who I'm sure is a million times smarter than me, not something I could ever do. Way too
nor could I.
Level. Way too high level, way too intellectual, and involves way too much work. Joe Patudo, your thoughts on this? It was fascinating.
Well, I have several. I loved it.
Yeah,
I would give the panel.
I thought you would.
Yeah, I did. I got a real kick out of it. I would give the panel an A+. They not only knew what law and had reread those cases clearly before they came in, but they were extraordinarily familiar with the record and what was in the transcript, which I also thought was just really great. And they were very, very, very familiar with the arguments in the briefs. So I don't know that they could have come in better prepared for this case. I can't imagine what they could have done better. I thought their questions were very good. As to the lawyers, I thought Michael Offerman was pretty good. He tried not to, that's what reminded me so much of law school, Jared. He tried not to respond to the first question that he got from the middle judge, whose name I don't remember. I'm just bad with names. Yeah.
Judge Rowe.
And she came back at him twice before he finally addressed or tried to address what she wanted. But I thought in general, he did a very good job. I was, Jared, less impressed with the state. I thought he was disjointed. He didn't start out giving making it more thematic and then going to what he wanted to say. He got a sort of a lob from one of the justices at one point and he didn't hear it that way. And he tried to respond when he could have just embraced the lob, and he didn't, which happens. I understand that happens when you're in the heat of an oral argument. You just can't hear that the judge is really helping you out sometimes. It was the judge actually that made an argument, or one of the judges that made an argument that he should have done in his answer. And I can find it here if I look a little. And I was surprised that he didn't. But I thought in general, it was a very, very good argument. I think Michael Ufferman did on this record the best he could. I was a little surprised that I knew that it was going to be the jury and the other stuff just wasn't going to matter. I was a little surprised he started with the change of venue rather than point 2, which was the jury pool being potentially tainted by the comments, and then move back to the change of venue, because I think that pretrial publicity, that argument about change of venue, I just don't think doesn't fly. Certainly doesn't fly on its own, whereas point 2 could have flown on its own. So, and then Jared, you may know this. What is a 3850 as compared to a direct appeal? I mean, they shouldn't use these Florida numbers and not tell me what the hell they're talking about.
3850 is the post-conviction.
It's ineffective assistance of counsel.
Yeah, ineffective assistance of counsel. So,
yeah. Okay.
Yeah. So, Tim Jansen, you were in the gallery for this. Your takeaway overall?
I think the questions by the judges were brilliant. I think they hit the points that were really important. One of the justices, Winokur, hit it right on. If you have a rule that says you have to file something in writing beforehand, but the Supreme Court says that you have to try to pick a jury, and then what are you supposed to do? Suspend court and then file something in writing? It defeats the purpose of having the rule. Now, they could have done polling and they could have filed something ahead of time, which they didn't do. I think Mike Ufferman did a great job for what he had. And you saw at the end what he said. The judges say, well, you're talking about ineffective. He goes, absolutely, I'm going to be talking ineffective and conflict, and you're going to see me again. Because it's clear from this record, the lawyer did not preserve, he waived, they did little preparation. They didn't even listen to the audio when they were given that chance. They did nothing. They just stomped their feet around and did nothing to preserve issues for appeal.
Yeah, Tim, I thought that was fascinating. That was kind of said in passing at the end by Michael Ufferman. He said that there was conflict of interest with the defense attorney, meaning Dan Rashbaum, and there was ineffective assistance of counsel. Why wasn't that argued this go around? Is he going to have to file some sort of separate appeal to argue that, Tim? And when would that happen?
Yeah, the 3.850 ineffective counsel has to be done after the direct appeal. So once this appeal is resolved, then he has 2 years up from the mandate of this decision to file an ineffective assistance, and I'm sure he will. And he said he will. Mike's already been hired, and he mentioned it on the record he is.
Yeah. COE, if you can start to gather up some questions, that would help me a ton. But Jared, one of the questions I saw asking our panel, not the panel of judges, but you, who are our judges, if any of these arguments influence you one way or the other. I mean, after watching this, Jared, you now feel that maybe, impartially, if that's even possible, if maybe Charlie does deserve a new trial.
I'll agree with both Joe and Tim that I think Michael Ufferman did a great job with what he had. And I know I saw in the comments a lot of people saying he's talking too fast or he's too loud. Or you got to remember, you have a clock in front of you ticking down. You have to get your arguments in there as quickly as you can, and you're being interrupted at every turn. So that's why he's talking fast there. I know in a trial court, you want to be slow and deliberate and, as clear as you can. This is a different animal. But no, I don't think his arguments swayed me at all. I think they were as persuasive as they could have been for the facts that he had. But we all have watched this. For those of us that are never going to be seated on a jury in this case or never going to work on this case. I think it was very well said by Charlie Lee that he's entitled to an impartial jury. He's not entitled to an impartial community or impartial citizenship. I can't remember the exact words he used, but we have information and we have seen things that jurors or prospective jurors may not have seen. He didn't sway my thoughts at all. But again, I think he did a great job. And I think that's why you've heard Tim say it. I've heard my wife say it, who has argued against Michael Upperman in that courtroom. He's very good at what he does. But at the end of the day, you have to remember there is a small amount of cases. I think it's anywhere between 8 and 9% of cases in the entire state of Florida that are overturned on appeal. It's a very small amount, and this is not one that I foresee being overturned. Yeah, certainly not on this appeal.
Yeah, and that quote was, Charlie Adelson's entitled to an impartial jury, but not to an impartial city, state, or world. Very, very eloquently stated. Adam Lamparello with a super chat. Thank you, Adam. And I do believe, Joe Patuto, that Adam is an attorney, hence the scales of justice. Even assuming defense counsel was ineffective, Joe Patuto, what evidence shows actual prejudice that the outcome would have been different with effective representation?
Yeah, and I will say that the state didn't argue anything on what you would call harmless error, which is even if there was an error here, would anything have been different?
Which they will argue if it goes to the 3850.
Yeah, that's right. The next time when they get back to the collateral attack, or the 38, what is it, 3850?
3850.
I thought that's what it was, but it seemed to me they should have said it better. Well, the argument that he's making, though, is that the kind of error that happened, you can't really show what the prejudice was because there's no way to pull up the veil and really find out that the jurors had a bias. You can't trust what they're saying, and he used the evidence of 2 to show that they might misrepresent or lie. You can't trust when jurors say, gee, I heard it, but it didn't affect me, that it is fundamental and structural that there's no way to demonstrate what the prejudice is, but the structural error says we have to assume that there's prejudice. That was the argument he kept trying to make, and I think he did a pretty good job of articulating it, and the judges had read the brief, so they knew exactly what he was saying there.
Yeah, if you guys will indulge me, I'm also just keeping an eye on Tim, who I think is trying to relocate to a better position. But claim 1 was the trial court failure to change venue. That's how Ufferman came out. By the way, he speaks like the guy at the end of a pharmaceutical ad reading the disclaimer, but you've got to do that. Speak quickly when you've got very limited time. And again, I see Tim trying to log on here. And then Jared, just coming right out of the gates here, he talks about striking jurors 51 through 101 or the failure to do so. He says of the 130 jurors, 54 had formed an opinion, and 53 of those 54 were guilty. And then right away, Judge Rowe snaps back and says, and they were excused, correct? And he has to say, yes. I mean, does that just blow his argument out of the water at the very beginning there?
It doesn't necessarily blow his entire argument out of the water, but it's clear that they weren't necessarily buying that argument. And he kept going back to the 2 jurors who lied. And let's remember, those were 2 prospective jurors who lied. They were not 2 impaneled jurors who allegedly lied. They're supposed to assume that what Michael Ufferman and what the defense is then saying is the truth, as opposed to assuming what those jurors said was the truth. So again, he kept referring to them as these 2 jurors who lied. They were not 2 impaneled jurors who made the decision of innocence or guilt. They were 2 jurors that were excused and never impaneled and never sat on the jury. That was purposeful that he kept referring to them as jurors. There's no doubt about that. But let's remember, they were prospective jurors. They were not two folks that sat there and determined whether or not Charlie Adelson was guilty or not.
The Kingdom of Lesotho is here along with Tim Jansen. So Tim, they talked a lot about an affidavit requiring a good faith statement. There was no affidavit. And then they go into this change of venue almost always need to be done during jury selection. These were arguments that Ufferman was making. And then the judge, after he says that the change of venue almost always needs to be done during jury selection, the judge responds, well, there's almost 300,000 people who live in Tallahassee. Was it so persuasive, the media, the judge says, that they would all be swayed? And Tim, when I came to your house, I stopped in a liquor store, asked like 5 people if they ever even heard of this case. They said no. Are they just not buying the argument, as maybe Joe and Jared are suggesting?
Well, the rule is kind of cumbersome because the rule says you have to do it in writing before, right? And then, but the Supreme Court says you have to try to pick a jury. So it could come out that during the jury selection itself, you find pervasive bias. And so then you probably have to judge, can I take a half-hour break so I can file my thing in writing to make sure I comply with the rule? That's a kind of a conflict that one of the judges mentioned in reality, because is that realistic that you're having to pick the jury, you find problems, taint, that's shown, but then you have to go back and put it in writing to make sure you preserve it. I don't think that's true. I thought issue 3 was interesting because when they didn't allow that evidence in, the Attorney General was saying sometimes you have to protect the defendant from himself. That is not the position a judge is in, okay? There is trial strategies at time that you have to get your client to waive. Like if you're going to say, I'm going to admit that I committed this offense, but I didn't commit this one. You have to, that's a trial strategy, but you have to get your client to consent to cover yourself. But the court cannot be in the position saying, I'm not going to say that because that may taint you. Now, the judge may off the record say, Mr. Defendant, you acknowledge that you've discussed this and you're waiving this, or you're going to enter this evidence that might be prejudicial. But I thought the Attorney General was wrong by saying that the judge's position is to protect the defendant from himself. And this went to that racist comment, misogynist comments on those texts that they wanted in. And they tried to say, well, they didn't preserve it. He said they wanted them all in. And so that is something that at least one of the judges, Winokur, was amenable to.
Yeah. Real quick, if you're on here, please hit the like button and subscribe. Goes a long way in growing the channel. We've got a Patreon page. Joe Patuto, there's a question here from Aristotle J4DM. So is the true issue for the panel pivotal on Rashbaum did not document his concern of bias due to news online coverage. So the record to rely upon does not exist for the 3-judge panel. Does it go back, I guess, to Rashbaum not documenting this concern is the essence of this question.
Well, that's what Ufferman ultimately said at the end. And if they lose the appeal, which I think is going to happen, and they come in on what Florida calls a 3850 motion, that's when he will make the argument. These things happened, they were prejudicial, and it was because it was ineffective assistance of counsel that it happened. So that's where they're going to do it. It's not lost. It's just he couldn't raise it in this appeal.
Jared, here's an interesting question. Thank you, Joe. Mom of the doxy, mom of Arlo the doxy. Hello, Arlo. Did you feel the court's comment that Charlie could have brought in witnesses to confirm his character rather than admitting all of his emails was effective and accurate? Does that go to ineffective assistance of counsel that I guess they didn't bring in some sort of character witnesses?
Well, I think you heard Ufferman's response to that question from the judge, which was absolutely, and we'll be back here to argue that, or at least he'll have a brief. Whether he gets an oral argument on that or not is to be determined. But I think that was the judge asking him, why are you not making the argument, or why are you not acknowledging that he could have done this? And him saying, we will acknowledge he could have done this. And the defense attorney did a bad job by not doing that. So it wasn't necessarily an argument from the judges, because remember, the judges don't make arguments, but it certainly was a question to Michael Offerman about that, and kind of tipped his hand, and we saw Tim kind of laugh there in the background when he said it. So we will see that argument made.
Yeah, go ahead, Tim.
Mike was giving kudos to the lawyers about the venue stuff, and at the very end, he's basically saying, yes, they were completely ineffective, and we're going to be here later on that issue.
Yeah,
Tim, what do you think? I mean, I think Rashbaum has to be watching this. What do you think his reaction to that would be?
I think he realizes he's got a lot more to learn about trying cases. He lawyer and realize on issues he's got to preserve. He should learn the criminal rules of procedure. They knew well ahead of time they wanted to change a venue because they made this. They should have realized that they had to file something in writing, and they should have realized that they should have kept objecting. We object, and I can't believe they didn't ask for extra peremptory challenges. And that's what the state attorney general said. They didn't even ask for extra peremptory challenges. And that kind of, even the judge said, it didn't show that they were preserving that issue.
Yeah. Joe from D here, are any of these judges showing their hand with the question they are asking? Can you get a sense of which way they are leaning right now?
Well, yeah, but the other thing is they are trying to satisfy themselves on the questions they have. So in a way, you can say they're tipping their hands. In another way, you can say they just want to be sure that the things that they pointed to that they think maybe have been soft in the arguments, whether they're right, whether the lawyer on either side is going to be able to satisfy them on a point. But generally, what they're doing is they're asking questions about the places where they have questions. Usually that tells you which way they're leaning, but it doesn't always. But I just don't think, I didn't think that this was going to be a successful appeal. When I read the briefs, I think it sounded better hearing the argument from Offerman than it read in the briefs, but I still don't think it's enough. I've been toying with the comment that he made about ineffective assistance of counsel. If I were on the appellate court and I had a genuine question about one of these issues, would I say, yeah, that's what really it is, so you come back later and make that argument and roll it in? Or would I say, yeah, that may be what it really is, and I've got a question already. Maybe we should handle it now and not cost more money and more time while this appeal goes up when the issue is going to come up. And so I'm sitting here trying to think which way I would lean on it.
Yeah. And Jared, by the way, this is a great point from Cowboy Girl 007. He had this guy, Josh Dubin, who some people said he was paying up to $250,000 to act as a jury consultant. Tim is shaking his head. Should that have been brought up by the state, maybe, to say, look, they even brought in an expert to handle this issue. Where was this guy?
I don't know that they necessarily needed to bring that up in this argument. I do think that will get brought up if there is another appeal, or I should say when there is another appeal. But again, it just goes to show money doesn't buy you the best things sometimes.
That is for damn sure. Tim Jansen, I mean, how many appeals can be granted? I mean, how many times can they go back and appeal this decision, this verdict?
So this is his direct appeal, and this court can decide which way they're going to decide. And then he can ask to have the Supreme Court hear it, which is very unlikely. And then they'll go after 2 years. Within 2 years, they can do a ineffective assistance of counsel, which I'm sure they're going to do. They're already preparing for it. And then they can appeal that. But that looks like the end of it.
We can go in federal habeas corpus, Tim, because he's claiming a Sixth Amendment constitutional right. So, I'm not going to say they're going to win, because they can certainly extend the amount of time they argue about it.
They can do that.
Yeah, Joe, what about just the fundamental issue of jurors in this country? I mean, they do a difficult job. They have to sit there. They're paid next to nothing. In a way, doesn't a lot of this just undermine the entire jury process? I mean, I know they've got to question it, but what about upholding that, kind of?
Well, they clearly are worried about it. And there were at least two questions that went to that. You want us to sit here and try to examine what the jurors said. Why shouldn't we believe them as compared to, your argument that you shouldn't? So I'm sure it's a concern with the appellate court here. What I don't understand, I didn't understand it when I read the briefs, and I don't think I saw that part of the trial, is why, with the arguments they were making, they didn't go listen to the tape. I mean, that would have given them presumably more concrete information. And the only thing I can think of is that they didn't want it, that they felt they were better off arguing what it might be than to find out that it wasn't.
By the way, Saudi Arabia is in the house. Shout out to Saudi Arabia, lest you think we are not a global phenomenon. Jared, so Michael Offerman gets up, and this was a very infamous case, and he makes the argument this is not like 1994. This is not like the trial of Danny Rowling, suggesting media has totally changed. And then the judge responds by going, "Look, I've turned off my propaganda box," referring to her TV set. She said she uses newspaper for something that I'd never heard of. It was I don't know.
Wrapping mullet.
What is that? Is that wrapping paper?
It's a fish.
It's a fish.
No, a mullet is a fish.
The hell do I know about mullet? I thought a mullet was a haircut.
Well, it's that too.
Yeah, what do I know? But anyway, that's what she uses a newspaper for, and on it went. So, she just, to me, she was listening. All three judges were obviously very attuned to what was going on, but basically said, "Get out of here." I just turned my TV off. But I don't know. That seems like an easily an argument that you could easily poke holes in again if you're Michael Offerman.
Well, you could try to poke holes in it, but you're also assuming that an entire city of 300,000 people or whatever our population is today, and it's a fairly transient population, as we've talked about a lot. There's a lot of people that come into this city and leave this city over the last decade. We've had a population growth, but we've also had a population turnover. So you're assuming that everybody that was here during Charlie's trial was also here for the 9 years leading up to that trial and listening intently to everything about this trial. And that's just not the case. You said it earlier, Joel, that you walked into a liquor store and talked to several people who had no clue about this case. I saw Abby's comment that she got into a Lyft and her Lyft driver knew nothing about this case. I have run into several people in this town that I know. So they know me, they know my, they now know my connection, but they had no idea about this case. So it's not like all 300,000 people or whatever our population is today know about this case, particularly when you're talking about the students at FSU, TSC, FAMU, those folks, and all the people that recently have turned 18 that can now serve on a jury that were, 12 years ago or 11 plus years ago that were 6, 7, 8 years old at the time. So it's not as pervasive as Michael Offerman or even Dan Rashbaum at the time would want you to think it is.
Yeah, and Evan Higginbotham was a juror in the Don Adelson case. He was on our show, and he was about that age. He's like, he's of age now, but he was a little kid, and he said he remembered hearing something about it, but didn't know. Tim, go ahead.
Joel, I think you made an excellent point, and the judge made an excellent point. They were using the rolling case decision. And I was a federal prosecutor in Gainesville at the time. I almost prosecuted him for the bank robbery until they found out that Danny Rowling was involved in the murders, and then my supervisor took the case. So I was there, carried a gun. The town was terrified. Media is completely changed from when it was with Danny Rowling. We didn't have podcasts back then. You didn't have YouTubers. People will watch the news. Everybody was watching the news and reading the papers in Gainesville and the Tallahassee Democrat. The news cycle and media and the way people get there has completely changed since the Danny Rowling murder and trial. And I think that's the point she was trying to make, is that people don't just look at the news. Social media, YouTube, podcasts, all these things are completely different than they were when Danny Rowling. We need to change the way we look at how people get their news in vetting jurors. And I agree with that.
Yeah, very good point. And to that point, Michael Offerman gets up there. He says it is not just print or local news, Joe Patuto, but people are getting information, he says, from cable news, YouTube. They mention Over My Dead Body. They mention the Preston Scott Show. He's been a guest. He has a big AM morning show. They mention, the local stations and the Tallahassee Democrat. And then the judge chimes in and says, well, we don't have the context here. Maybe some of them are painting Charlie in a positive light, which I kind of chuckled at because I don't think I'd say 99.9% are not painting him in an impartial or positive light. But what about that? I mean, there is so much media out there, and Ufferman did a good job to point that out, but it didn't seem like they were buying it necessarily.
Yeah, I agree with you that most of the podcasts and the YouTube stuff would have been very negative. I'm not so sure about the newspaper and the broadcast. They might not have been sympathetic, but they were probably more neutral. It's a place where I didn't think the state did as good a job as it could have. I thought most of what Jared's answer was to the transient population in Tallahassee and what happens there is what the state should have said in response to those arguments about the pretrial publicity. The best he said was, as I recall him, well, it was 9 years ago or whatever it was, which, at trial, Rashbaum argued that made it worse because it was 9 years for the constant pounding. And there were, 4 different trials or 3 trials at that point that kept happening. So, the point is, unless you're not going to have criminal trials, that's the world we live in right now. So you can't say because there are podcasts, because there are YouTube, people, documentaries, that therefore you presume prejudice in the jury. That gives you a null set. Murderers will go free. Rapists will go free. So I think he could have given a better response to that. But I also think he should have acknowledged that, because he kept saying, we don't know. I think he could have acknowledged that there may have been, negative publicity in a fair amount, but that doesn't prove that any of the potential jurors, or certainly the ones who sat, were prejudiced. And you shouldn't be able to presume that they're lying when they say they either never heard of the case or heard about it but didn't hear it didn't hear particulars, or heard about it but hadn't formed an opinion. I mean, it seems that's where I think that focus should have been, instead not arguing that we can't show that we don't know whether there was any pretrial publicity at all, because I just think it may not be in the record, and he could have said that, but I don't think it's persuasive or plausible to say that we don't know that there was any.
Yeah, there was a couple. I mean, there was many places where I got completely lost. But Tim, there was one example where Ufferman said, one juror posted that the Markels should assist in the killing of Sigfredo Garcia. Did you catch that? I didn't. I wasn't sure. Oh, you're muted, Tim. Or you're not muted, but your volume's not coming through. I don't know why. Talk to me. Yeah, you're there. You're there.
I heard that reference. I didn't catch it. I was trying to take notes on really the judge's questions to get a flavor. Someone came up to me afterwards and said, well, the ones that the judges hit the hardest usually lose. So I don't know if that court is correct.
Yeah. And then again, Joe Patuto, not to harp on this, but to harp on it, the panel of judges kept saying, well, you could have just reviewed the tape of what was happening in the Venire in that room. Why didn't you review the tape? I don't know. In hindsight, is that something that Rashbaum should have done, or this high paid jury consultant should have done? Is the onus on them?
Yeah, if they're going to argue that they believe that there was bias or the jurors were influenced by these statements and there's no way to get at it, they had the opportunity to listen to everything that happened in that jury room. And I'm really surprised that they didn't do it. I mean, what would it have taken? A couple of hours or however much time it would take to listen, and then you might have been able to make a better argument. That's why I was wondering whether they didn't want to know. They thought they'd be better off not being confronted with evidence that didn't help, or being confronted with evidence that didn't help. I'm better off arguing what might have happened or what we can't know whether it happened or not, rather than risk finding out and knowing and then discovering it doesn't help you. But I think, I mean, if I were on the panel, and I think you got that sense from all three of the judges, certainly two of them, that's not going to be helpful in this appeal, that they're making that argument, but they didn't take the opportunity. Two things, Tim said they didn't ask for more peremptories. They also didn't take the opportunity to hear what in the world happened from the jury. What is it, 51 to whatever it was, 100? That group. Now, on the other side, it seems to me Ufferman has a good argument there. How much would it have hurt? You knew that there was a potential issue. The defense is arguing about it, to just drop that group. You had another 50 downstairs and just go do it. I think that's a pretty strong argument for Ufferman on points 1, 2, or mostly point 2, but the combination of the two.
Yeah, the issue was jurors 55 through 102. I love how they say, "May I please the court?" And at the beginning, whatever they say at the beginning, for the great.
May it please the court.
Yeah. But Jared, let me and Tim, I'll come to you in just 1 second. But I don't expect you to know these cases, but I just find it fascinating. So I think it's Charlie Lee. Is that it? He is the attorney for the state. He comes out. And he just starts citing Manning, and it goes from Manning to Armstrong. He talks about these Batson challenges. This is really a different world, and your wife's in this world, which is why I'm asking you about it. I mean, what do these people do? Does your wife study case law at dinner? I mean, how do they know all of these different cases? It's crazy.
Well, a couple things. One, yes, they study a lot of case law, but a lot of these cases end up being precedent for a lot of the same cases, a lot of the same arguments that you see in cases. So, she deals with she deals with all criminal cases. That's all she does. So a lot of them are about, jury pool issues, change of venue issues, things like that. So I don't want to say there are templates for briefs that they can go to, but there are templates for arguments that they can utilize, which definitely makes their job a little bit easier. But yeah, they do go through the case law quite a bit, and it's not rare for my wife to come home with a giant stack of case law that she then, after dinner and after we're done, helping the kids with their stuff, that she's going through and she's reading through and she's working on a brief. And it's just, that's the world that she lives in. I personally have written one appellate brief. It was my brief in law school, and I never want to do it again because there's nothing brief about a brief. But she does. I mean, she has 2 due this week, and got 1 done yesterday and has 1 due on Thursday. So I don't know how they do it, but they get very skilled at it.
God bless her. I could never do it. Could never, ever do it. Tim Jansen. So the attorney for the state, said, let's look at these 12 jurors. He said Adelson, the defendant, accepted them. All of them, the 12, said that they would be fair and impartial. And then he goes to this issue of affidavits not being sent out. So we simply don't know. What is this? I mean, are affidavits typically sent out where potential jurors have to sign sworn affidavits? I mean, I didn't follow much of that. So fill us in here.
Well, you can go out into the community and have an investigator go poll the community, go interview people, go interview 100 people and see how many of them will say, yeah, I've heard this case. What's your idea? What do you think? And they may say, I think he's guilty. If you get about 60 or 70 out of 100 that say that, that would at least be something in the record that they could produce and enter into the record, which they did not do. And as far as your last question to Jared about the Batson challenge, Batson challenge are a specific issue when they cut because of their race, religion, their gender. You have to make that Batson challenge right there. Then the state has to give a race neutral or a neutral reason why they cut them. If you don't preserve it, you've waived it. That's a whole nother body of work, but all trial lawyers know it. And like Jared said, some of these cases are pretty much They're precedent cases. They know the facts backwards and forwards. So all they got to do is weave the facts in this case under those holdings. And those are Supreme Court cases that they use regularly. So they clearly have a good knowledge of those cases and are very effective arguments.
Yeah, just a couple more questions, and we'll get some final thoughts here. If you're just joining us, the appellate hearing just took place for Charlie Adelson. Very fascinating. Ended up being about 58 minutes. Both Charlie Adelson's appellate attorney and the state argued their cases. The judge here, Joe Patuto, said that I guess that they did show that of 54 jurors, 53 did say that Adelson was guilty or had suspicion of his guilt, but those jurors were not picked to be in the jury pool. Another judge chimed in saying that there was a lot of speculation there, citing, I'm just looking at my notes here, citing the Singer case regarding impartiality of the veneer. And then the attorney for the government, Joe, said, I thought this argument was a little weak because he said 40%. So 40%. Yeah, he said 40% of this pool said they couldn't be fair and impartial. But then he cites another case, Irvin, 2/3 of those could not be. So he's like, look, here's 40%, but in this case it was 2/3.
Yeah.
Didn't seem like a very compelling argument.
No, I did the numbers when I read the briefs. There were 130 in that pool. 34 said they never heard of the case at all. 42 said they had heard something but could be fair. So that's 76 of 130 that could sit. You know, what he did was he and it's a trap you get into. You follow the way the other side has framed it, and then you try to make the best argument on the framing, when the better way to do it is reframe it. So you're talking about 76 out of 130. That sounds pretty good. I mean, yeah, there were a lot, that you're dropping. And then the judge that's the one that he didn't embrace from the judge. And I thought he should have made an argument about it anyway. One of the judges, the woman on the far right, as we're looking at it, said, I think it was she, said,
Thomas.
Well, couldn't some of those jurors who said they couldn't be impartial be jurors that were lying because they didn't want to sit on the jury? Right. Which is exactly the point about you can't speculate about what's going on. And I'm sure that's true that there were some, who just didn't feel
I was on jury
sitting.
duty.
Yeah,
I had to sit jury duty 2 weeks ago, and I had a conflict on the day of the trial, so they ended up not picking me. I was afraid they were going to pick me. But there were people in the 21 of us that were in the jury box getting asked questions. I knew they were lying about whether they could be impartial or that there were issues. Like, I knew it, but you can't speculate that if you're the state or you're the defense. No. So it's an excellent point.
He could have framed it by saying, look, we can't be sure about these numbers either, because we all know that some people just don't want to serve on a jury. But even if you accept their number, 130, 34 said they never heard, 42 said they could hear and be fair. That's still 76 out of 130. And if you're going to accept the representation of the 48 or 50 who said they formed an opinion and they couldn't do it, how is it that you can pick and choose which juror representations you're going to accept? Because you've got the ones on the other side who said we heard something, but we can be fair. What Ufferman essentially did was, you've got these representations from the jury. These we accept, and the ones on the other side we discount.
Yeah.
You either take them both or you take none.
Yeah, exactly. Tim Jansen, what just give us color inside that courtroom before the appeal. Before the hearing began, we saw Ufferman just pacing back and forth. Someone said, I hope he's on heart meds. He's not drastically overweight, but he could probably lose a few pounds, Mr. Ufferman, no offense. But he's high stress, man, talking quick. What was the mood like in there just prior to him going up to the dais to argue his points?
That's a great point. And I did a video. I wanted you to see the courtroom so you can see how immaculate it is.
Yeah, it looks beautiful.
And that is Michael goes into a little conference room right outside the courtroom. His assistant Laura will get all the paperwork and tons of binders of case law and everything. And then Michael does that. He gets in that's his game face. Last time I saw him do it, I talking to her, she goes, that's how he gets game ready. He paces, he thinks in his mind. You can't talk to him the last 5 minutes before the argument. That's where he gets his mind ready to, and then he gets on that, and it's like a track star. He gets on that, once that goes, he kicks it off, and that he's going. And he speaks very fast, he makes his arguments, answers questions, and he stays on point. And even when they tried to take him off track, Michael's good to get back to a positive point for his client.
Yeah, well said. Look at this. Niagara Falls, Canada loves Joel and STS. We love you back. I saw pictures of Niagara Falls. It's frozen. It's crazy looking. If you're actually by the falls, take a picture and send it to us, survivingthesurvivor@gmail.com. It looks absolutely beautiful, but it also looks like something out of some sci-fi movie. Jared Ross, his better half, and he would admit this, she is an appellate lawyer, so he lives this world vicariously. Jared actually loves it. He won't admit it, but Jared loves everything to do with appeals, and he sort of likes the Yankees, but he likes the appellate stuff more. Jared Ross, one of the questions that the judge asked, because Ufferman was bringing up the state was bringing up the Rowling case and how he was cast as a Ted Bundy figure, And then at that point, the judge asked the question, is it really the judge's job to protect the defendant? Which I thought was an interesting question. Your thoughts on that, and just your final thoughts here on what we all witnessed today.
Yeah, I think Tim kind of hit on that earlier, that that's not something the judge would normally do, is protect the defendant from themselves. It's the defense's job to defend the client, and his job to protect himself in that process. So I was a little thrown by that argument by Charlie Lee, by the attorney, but we'll see whether or not that was persuasive, or if it even comes up at all. Just my final thoughts, a couple of things I want to hit on. I've seen people asking about whether or not there are oral arguments on every case, and whether or not, or what the timeline is on this. No, there are not oral arguments on every case. They do not go through this for every appellate case, or that courtroom would probably be in use 24/7 every day, because that's how many appeals there are. They typically, appeals are decided on the briefs. So it's a lot rarer for there to be an oral argument. In fact, I can tell you that's one of the things why Ufferman seems so much more comfortable, is he does more oral arguments than the Attorney General's office does. Mm-hmm. Those attorneys are not in the appellate court all the time. In 19 years, almost 20 years with the Attorney General's office, I think my wife has done 15 oral arguments. Maybe. They just don't happen all that often. So the second part was, how long is it going to take? About 90% of these cases, the decisions come in about 180 days. So it's not a quick process. You're talking about anywhere from, I actually texted my wife while it was going on, and she said it could be 2 to 12 months. You just don't know. Mm-hmm. Or it could be tomorrow that they come back with a PCA, a per curiam affirm, where the three judges don't even issue an opinion. They just say, we are upholding the lower court's decision. Sorry, my wife's actually calling me right now. But
telling you you're wrong.
Yeah, exactly. So no, she's probably not watching this right now, unfortunately. But I thought again that Michael Ufferman did a great job with what he had. I thought Charlie was fine, because I thought he knew the facts were on his side. I thought he didn't necessarily have to come out as aggressive as Michael Ufferman did. And I think that's why he was kind of more measured and, less animated and maybe not as argumentative. But I do think that the conviction is going to get upheld. I don't think that he's going to get a new trial, but I do think we're going to see another appeal. So just appreciate the opportunity to be here again. And I'm sure we'll be back for Donna's appeal in the next year or so as well.
Yeah, Jared, thank you so much. Genesee Galfoy, one last question. Well, you just said about, what'd you say, about 12 months? It could be up to 12 months, but they're going to
it could be any time. Yeah.
Okay.
Yeah, they will publish a ruling, whether or not it's a written opinion or whether or not they PCA it, per curiam affirm, where they don't issue an opinion. They just say, we agree with the lower court. But they will issue an opinion.
Joe Patuto, my question, what are the judges, what are they doing right now? I'm so curious about what do these people do all day? What is this panel of 3 judges? They have offices. Lunch. What the hell are they doing right now? What do they do the rest of this day? They're reading a lot of
briefs.
Yeah.
Because every appeal, you may not get an oral argument, but virtually every criminal defendant appeals. So there are briefs that they're reading trial transcripts, or they're having a clerk, a judicial clerk read the transcript and highlight what they need to look at. They're doing a lot of that. I don't know, and Jared may know, whether the panels in this district convene after the oral argument and get a read on what they're thinking, and then how they assign who's going to write the opinion. Some panels, it's just a rotation, and you can have the weird situation where somebody in the dissent ends up writing the majority opinion, the opinion for the court, because it's just done on a rotating basis, or whether it's assigned. But they have to do that. They've got to decide who's writing the opinion. A lot of these panels, you circulate opinions around because everybody has got to sign off. So it's, and then again, they're not hearing a lot of oral arguments, but they're hearing some. So it's a full-time job. I mean, writing opinions, Jared talks about writing the briefs. Well, writing opinions is no walk in the park either when you have a lot of them you're doing. Even with a clerk who may do a first draft, it's still a lot of work.
Wow. I would just never be able to do it. It's the same argument over and over. Rich, arrogant people who think they can get away with stuff. Maybe the state should have presented it that way. Big thanks to Joe Patuto. Prof. Joe Explains on YouTube. Tim Jansen, you get the final word. You know, we were talking about this before you were on. Do you think Georgia watched this? Does she, I don't know, does she involve herself? Not involved, but does she care enough to actually watch? And what about Judge Stephen Everett? Did Judge Everett log on to Surviving the Survivor today to check this out?
I'm sure Georgia watched it. I didn't see anybody from their office there today. I think we might be undermining the effectiveness of Mike on issue 3. I thought that was his most effective argument, was when they argued about the text messages not coming in. Judge Winokur says, well, you said he didn't preserve it, but he wanted them all in. And then Michael went into the closing argument of the prosecutor, in which they argued, well, we don't know the context of those calls. So they were objecting to evidence that they thought was relevant, that was kept out, that was preserved, and then they utilized it in their closing, knowing that they kept out that evidence. I think the judges might be sympathetic to that issue.
Well said, Tim Jansen. Ain't no hollow back, girl. Go Pats. One of our Adelson commentators, John Singer, is on his way to the Super Bowl. He's a diehard Pats fan. This is like his 9th Super Bowl. He goes to every game, and he's taken his son. And I said, as a Giants and sometimes Jets fan, I'm rooting for you. And this shows the competitive nature of John Singer. He says, I don't want your whatever word he used. I don't need it. I don't want anything hollow. He's like only diehard Pats fan. So you know what, Singer? I'm rooting for the Seahawks, Singer.
Right.
How about that, you dog hater? Sorry, John.
Dog hater.
So on that note,
that's like all the people that gave me crap for rooting against Miami in the national championship game. I'm a Seminole. The last thing I want to see is Miami win a national championship.
Well, I rooted for the Big Ten. So.
Yeah, well, Jared, Super Bowl pick. The Seahawks or the Patriots? Give us a pick. We'll go around the horn.
I think everybody believes the Seahawks are the better team. I think the Patriots win. I think we're seeing a similar to when the Patriots were the first Super Bowl with Tom Brady, where no one gave them a chance, and then it started a dynasty run. I don't like them. I'm a Jets fan, but I think the Patriots are going to win.
Joe Patuto, you're a Nebraska fan, but what about the Super Bowl?
Well, I'm Giants and Yankees.
Yeah.
You know what?
Gotta root
I don't
against
care, frankly. But if I had to go, it would be the Seahawks. I think they'll win.
Are you excited to see Bad Bunny perform the Super Bowl halftime show, Joe Patuto?
Absolutely not.
Yeah. By the way,
That I have an opinion on.
Karm the other night said, I'm going to watch the Grammys. I'm like, why? What is she doesn't know anything about music. She's like, I don't know. And then she called me after 30 seconds, like, I cannot watch this for another second. But politics aside, Bad Bunny was a grocery bagger in 2016. Imagine that. He was bagging groceries in 2016, and now he is going to have the Super Bowl halftime show, which ought to create that's what's going to trigger the civil war in our country. Bad Bunny doing the Super Bowl halftime show. So take cover, everyone. Tim Jansen, are you excited for Bad Bunny and your final prediction on the Super Bowl?
No Bad Bunny for me. I'm a Patriots. I got land and a farm in Massachusetts. And I agree. I think the Seattle's got a great team. I think they've got their head full how great they are. But Mike Vrabel is a great coach. He's played in the Super Bowl. And I think Drake May is the second coming of Tom Brady. Go Pats.
On that note, love you, America. Go Giants. Go Yankees. Go Rangers. Big UFC fan. Charlie,
You missed basketball.
Knicks. Correct. Nice. Thank you for that. Hi from Pigeon Forge, Tennessee. Talking about the best guests. Thank you to Genesee Gal, Pigeon Forge, Tennessee. We really have the best guests. Not a tagline. It is our reality. Tim just disappeared. Thank you to Jared and Jared's wife. Jared, your wife, they want her on the show. We'll get her on the show. Joe Patuto,
not allowed to.
Oh, sorry. So you won't see her on the show. Prof Joe Explains on YouTube. We're keeping a close eye on the very disturbing story regarding Savannah Guthrie. If there's a press conference, we will take it live, and we will have a show on it at some point today. But you got to follow me on Twitter at Podcast STS, or on X at Podcast STS, or on Twitter at Podcast STS, and Instagram at Surviving the Survivor. And that is my Michael Offerman impression right there. See you, everybody.